It was summer 2016, and I was on my holidays sailing. Sailing is great because there is no cell coverage, no contact with the business world. But that ended. When I was approaching the dock with the yacht, my phone got connection and started to get red hot from the messages coming in. And these were not my birthday wishes. These were messages from my team and from the client about the project we're advising the client on that went wrong. And you may think it ruined my vacation. Well, it did, but not so much. I had to readjust the plans. I had to take the evening and spend it with my laptop, making calls and answering emails. But it was just another IT project which went wrong that month.
And this happens more often than you think. With IT projects, it's like what Terry Pratchett wrote in one of his books, 1,000,000 to 1 chances crop up 9 times out of 10, because the most unexpected things can happen in an IT project. And the statistic shows that over 60% of IT projects fail. And well, when they fail, they usually end up in a dispute. Well, it might be true also for other business areas. There are lots of failed projects, then they get litigated, arbitrated, mediated, you choose. But what makes IT special and why we are talking about this today is that it's really difficult to navigate an IT-related dispute. And this is because IT projects have several special traits that are unique to the field of IT.
I like that navigation reference. But switching to those special traits, 5 issues are those that we take from our experience from our litigation history that we want to share with you today. And let's start with the obvious one, intangibility. When you have an IT contract, you create, but what do you create? It's not like real estate. It's not like automotive industry or shipyard to that matter. You create something which is invisible. It's intangible. The product of IT cannot be seen. Therefore, errors, problems are difficult to be spotted. And that makes conveying the message related to the problem, explaining the problem, difficult to both decision makers and to the judge. In addition, the IT, understanding IT, because it's invisible and difficult, requires a high threshold. I mean, it's a high threshold understanding thing. And you need to spend a lot of time learning. And that also makes access to advising on IT well quite high. And on top of that, when it comes to disputes, a challenge is the short shelf life of IT products. Compared to 6-7 years long litigation, an IT product won't last that long. So if you're litigating about such product, I mean, at the end of the litigation, no millennial will be happy about that product anymore. In addition to that, nothing is impossible in IT. And that obvious statement actually creates interesting legal questions. Can you cure a contract or can you not if nothing is impossible? What's actually the breach of a contract in IT? And finally, being on the legal aspect of matters, I mean, it's lovely in IT that there is no precedent of everything you need to start anew. You don't have authority. You don't have court rulings usually that resolve the problem you're dealing with. You need to carve your own path. And having those 5 issues in mind, is it worth to litigate an IT project at all?
Well, in this webinar, you will learn when to file a claim. When is it better to avoid courts? When terminated project becomes an asset that can actually bring you money, or when a project can bring money only to your lawyers.
My name is Wojciech Jarosiński.
And my name is Kinga Duda.
We are from Maruta Wachta Law Firm. And for 27 years, this law firm has advised clients on IT and new technologies. And only in the last 5 years, we have helped clients in more than 200 IT cases, which value exceeds 1 billion euro. And on top of that, we have settled more than 40 cases, which value exceeds 2 billion euro.
With this kind of expertise and experience, we can tell you IT projects can go wrong for many, many reasons. Well, for example, a project can be abandoned by the parties, Or you can have a vendor who is a little bit too ambitious and decides to undertake a project he cannot really deliver on. Sometimes parties decide to have a controversial business model and it doesn't go well. Or you can find yourself in a vendor lock. On some other occasions, parties decide to cooperate closely and it's just a failed attempt and then the project fails. So today, based on our litigation workshop, we picked the best elements and merged them into 5 storylines that will help us answer the main question of this webinar. Is it worth to litigate an IT project?
Now, I hope we can bring an answer to that question.
We'll see.
And let's start with a vendor who developed a document management system. And that vendor was deploying and maintaining and servicing its system in the financial sector. Why financial sector? Because it brings money. That's where the money is. And our vendor was spotted by a PM from an insurance company. For this presentation, let's call PM Charlie. So Charlie saw vendor and his software, and he thought it's marvelous. It will fit my organization just perfectly. So he approached the vendor, they discussed the terms and conditions, and they signed a contract with the insurance company. Implementation began. And Charlie, you may remember this guy, he was so invested in the process. He was so passionate about it. He wanted to make that document management software in his organization. And also the vendor, I mean, there was this magic between them and they worked so well during the implementation. Charlie thought, let's go to a conference of insurance IT departments. And they went there. And the presentation went great. They showed what they are doing. The presentation was awesome. It went great, but not for the vendor. That's actually where all the drama begins, because Charlie was so good with this project that another company approached him and Charlie was stolen by another company. So the project with our vendor at the insurance company was left without Charlie, and new PM was appointed. But the new PM, he had no interest in the project whatsoever. He was not the front-end guy. I mean, he had some interest, like top 5 minutes if he skipped his morning coffee and actually could afford those 5 minutes. And our vendor, from being the beautiful swan, he turned into ugly duckling. And what that means at the UAT stage.
What is actually an UAT?
UAT, good question. User acceptance test, almost the end of the project, almost like the finish line. And during these UATs, contradicting change requests, baseless errors, lack of coordination, delayed communication. The new PM, he invited half of the company to join the UATs, user acceptance tests, because he didn't want to bear the responsibility for the project. And those users, they didn't have time to read documentation. They didn't have time to go through test scenarios. So they submitted those baseless errors and they were actually change requests. Perhaps founded, but there was no budget for change requests anymore. The insurance company got annoyed with the situation, lost interest, and terminated the contract. Because the implementation was taking place in the insurance environment, for the security reasons, termination resulted in disconnecting vendor from the infrastructure. And that was a problem. Because all work, due to security reasons, took place on that infrastructure, right? Yeah. Security. And once disconnected, vendor lost access to his coding, to documentation, even to submissions where he was claiming that there was lack of cooperation. Why? Because Jira, the software where the communication was taking place, was also hosted on the insurer's premises. But the vendor had great claim, right? No cooperation under Polish law, perfect conditions for claiming entire remuneration, almost like money for free. But he had no case. Basically, if you have no evidence, you cannot prove a single thing. And you may ask a valid question. Why didn't they secure evidence? Why didn't they go to court and ask the judge to issue an injunction to secure the evidence? Well, when the vendor received termination, he was surprised. And he thought, okay, I will have conversation with the buyer, with the insurance company, and maybe I will convince them to change their minds and continue cooperation. And they started that conversation. Obviously, everybody wants to talk. And days passed, weeks passed, months passed. Half a year later, we are drinking coffee with Kinga and the law firm, and we get this call. And the client says, litigate. And we are, okay, with pleasure, show the evidence. There was no evidence, and after evaluating this case, even though it was perfect claim, the client decided to drop the case.
But sometimes it's not the buyer who derails the IT project. Sometimes it's the vendor who decides to bid more than he can actually chew. And it was the case for Tim. Tim is the head of an IT department at a car dealer. And when the pandemic started, he was tasked with implementing an online retail system. Well, pandemic meant that everything had to move from on-site to online. So it was a really necessary thing to implement in the company. Team had this idea that the system will be innovative, so innovative that it will be uncomparable to anything available on the market. But it also had to be done quickly, as soon as possible. So team started to look for vendors. Well, there is pandemic. Everyone wants to go into online retail systems. So the vendors who specialize in this field, they are in such a high demand that no one is available to help team. So team started looking at the vendors that he was already cooperating with in the company. Well, at first, no one was willing to undertake the task. It was a difficult system. But suddenly, one of the vendors who was actually responsible for a completely different system in one of the areas of car dealership business, he volunteered and said that they're going to make it. But it was surprising because this vendor had actually absolutely no experience in online retail, but they were really ambitious and they wanted to develop their market presence in the field of online retail. So they thought that this will be a great opportunity for them. Well, team accepted and started preparing very detailed guidelines, requirements. He was describing all the functions that the system should have. And this would include VR, on-drive simulations, almost Formula One experience, something that for the client will mean a car dealership experience moved to the online setting. Vendor looked at all these requirements, at all these guidelines, analyzed it and said, we can do it. Team was happy and the implementation started. Well, the very first stage of almost any IT project that includes implementation is the analysis. And as early as that, first troubles started appearing in the project. Well, it turned out that the vendor actually have no know-how on how to develop and implement an online retail system. They also had no resources because the programmers that were working for them didn't have the necessary skills to code the system as it was needed. And unfortunately, there was no cure for this issue, for this project, because due to the pandemic, all the programmers that were dealing with e-commerce, that were coding online retail systems, they were just fully booked. They couldn't help team, they couldn't help the vendor. And as time passed, as the IT project was progressing, the things were getting worse and worse and worse. And team really cared about this project. So he was trying to help. He gave them second chance, third chance, fourth chance. But let's face it, he started to lose his calm at some point. And that was the moment when he faced the decision time. Well, the clash. Should I stay or should I go? Should I push for this project or should I just give up and terminate the contract? But surprisingly, if you would ask the vendor about the situation, you would get a completely different picture because the vendor would say that everything works fine, the things that were delivered are exactly as team imagined, and basically they're on schedule, everything is going to be perfect. But in reality, it was definitely not perfect. All the functions were delayed by days, by weeks. The things that were delivered were of such inferior quality that they didn't pass a single functional test. And the system looked nothing like what team imagined, and it had none of the functions that team described in the requirements. So team decided that there is no way this can work out and terminated the contract. With termination, there is very often a conflict, and so was in this case. And at some point, we received a call from team. Team was seeking advice on how to deal with the issue, how to resolve the conflict between the buyer, the car dealer, and the vendor. So we analyzed the case. Team told us what are the circumstances, what they expect. And it turned out that the situation is actually twofold. On one hand, the car dealer wants money, wants to retrieve all the money they invested. It was a really expensive system, so they put a lot of money into it. They want it back. But on the other hand, well, they really don't want to bury the vendor, or keep in mind that the vendor was responsible for another system in the company. So they couldn't really push them to the point where the vendor would go bankrupt. And with a claim for this huge amount of money, that was a likely scenario. But after evaluating all this and all the circumstances, we came to a conclusion that this is actually a perfect claim for litigation. Well, everything was there. Evidence was there because all the implementation happened on the buyer's infrastructure, so they had all of the evidence. Well, the non-performance and improper performance of the contract was obvious. Delays, poor quality, well, nothing worked. So they didn't even need an expert that would have broad knowledge in some very narrow field. And one of the things that are often omitted, but are actually very important, the buyer could afford the litigation and also could wait for the conflict to be resolved in a few years. Well, despite all that, parties settled. And you may ask why. Oh, they settled because of one very important factor: the business relationship. The parties really wanted to maintain the business relationship. They didn't want to burn the bridges between them. They wanted to keep cooperating. They wanted to create new business opportunities in the future. So they weren't willing to go to court with their claim. And well, to be honest, I think I can risk saying that this was almost a certain win for the buyer at court. But even in those situations, when extraordinary circumstances arise, like the thing of the business relationship, sometimes even the best litigation case can be simply settled.
I don't buy it. I'm a petrol head. I cannot imagine car experience in the internet.
Well, team did.
We had two parties here, and with two parties, things can go wrong, right? Imagine what happens if you add third player to the game. That happened to Peter. Peter is actually my buddy from the times of the university. And he's a deputy CTO in a company which creates things out of plastic. For the automotive sector, like those things around like mirrors or those little baskets you have in the trunk. And Peter, even at the uni, he always liked to have everything organized, and that's how he ran his IT, neat and tidy. Each server was placed perfectly in the rack. Each server had a colored cable plugged in with a label and with description on the side, like everything was cool. And when it comes to software, he liked to have his vendor support working well. And we know each other for quite a while, and we're discussing IT matters over coffee often. And at certain points, this new idea came to the town. You will know it was a long time ago. related to third-party support, not vendor support, not the producer of the computer program support, but support from a third party, not the producer, which was offered for that software. And you know what? Peter enjoyed that idea. Why? Because unlike the vendor support, they actually gave him SLA. It actually gave him somebody to call to. And the unique selling point was that it was half price. And Peter is from Krakow. And
that's unfair.
Sorry. And Peter signed a contract with the third-party support provider for his software, and everything went really well. I mean, it was working fine. And then I think it was sometime before the pandemic, we're walking together in the court,
right
and
before.
we see Peter sadly sitting in front of a courtroom. We are approaching him and asking what happened, and he says, "Do you remember that third-party support? I'm called as a witness. It didn't go that well. What happened? There was a piece of software that contained data, and that data had to be presented somewhere, and it was presented on a browser. And you may remember a long time ago there was a browser, Microsoft Internet Explorer."
Well, no offense to anyone, but has anyone actually ever used Internet Explorer for anything?
We are not supposed to joke this way, but thankfully Internet Explorer, it changed into Microsoft Edge at a certain point, and the data from the system was unable to be displayed on Microsoft Edge. It was not compatible. So what Peter did, he reached out to the third-party support provider and said, "Please deliver an update to the system." The third-party support provider responded, "We can't deliver you an update. Updates are delivered by the vendor. We can send you a patch." And Peter agreed, and they sent the patch. The patch worked. Oh, it worked pretty well. The data displayed well on Microsoft Edge, but the patch killed performance. Like everything worked on the browser, but except for the browser, nothing worked like really. So Peter was called by the board, which started investigation. And the board, when board calls IT, also requests lawyers. Lawyers bring contracts, and that's actually often where problems begin to happen. And the lawyers and the board asked, where is the vendor support? Peter said, "We don't have vendor support. We have this excellent third-party support." So the board said, "So ask them to deliver updates." Peter said, "No, they can only deliver patches, but the patches don't work." So Peter, with his lawyers, contacted the third-party support provider and requested update. Guys obviously responded, "We can deliver you patch." And Peter said update, they said patch, update, patch. It went on, escalated lawyers, escalated to the court, and that's where we meet Peter, in the courtroom.
Exactly.
What was the source of the problem? First, the definition and the scope of the obligation was not that clear. It was ambiguous a little bit. It was not our contract. And that obligation was also trying to define a controversial business model. And with a controversial business model, you must be really clear on the words you use. Otherwise, it can create a lot of problems. You may ask, why actually the third-party support provider didn't reach out to the vendor and buy the update? You see, this is not how this works in the IT world. When you abandon your vendor, the vendor is unhappy. And when you want to return to the vendor, he still will pretend to be unhappy and will ask you to cover payments for all the time you were not cooperating with him, for all the services you missed. And that's a lot of money. Peter and the third-party support provider didn't agree on that money, and they went to the court. And that was a mistake, because they didn't realize who the real opponent is in this case. Had they worked together, had they cooperated and figure out a way to fix the patch, or figure out a way of communicating with the vendor to optimize the costs for delivering of the update and buying the historical services if necessary, they could avoid costly and lengthy litigation that benefits only the vendor. And the litigation wasn't easy. It was mainly about contract interpretation, but There were some little issues with technical matters, and expert witnesses were involved about the patch itself, but it wasn't important. It was contract interpretation, and that means plenty of witnesses who remember something, but not that well, and it's entire difficulty in proving your case. It's literally a toss of a coin decision in a litigation that easily could be avoided.
Well, if you think that a story where there is a big player, small players, and it all got messy, it can actually get even messier. And unfortunately, Mr. Fox have to face such a very messy situation. Mr. Fox is a CEO of a Norwegian producer of made-to-measure furniture. And one day, Mr. Fox gives us a call. And what does Mr. Fox say? Get us out of the vendor lock. Well, you may wonder, what is a vendor lock? Well, vendor lock is like having only one accountant in the whole company that knows how to file taxes, what taxes are due, and in general, how to deal with them. So it means that you are so dependent on your vendor that in order to get rid of them, you need to replace your whole IT system.
I have other metaphors in mind for that.
Well, it's a really difficult situation. And for Mr. Fox, it meant that their vendor was in control of the infrastructure, all the source code, the development of all the software and systems, and the maintenance of all systems. So basically, everything in IT department. Well, it gets worse. Not only the vendor was in full control of everything, they were also performing poorly. And Mr. Fox was not happy, things were not working properly. And on top of that, well, you see, it gets even worse, it gets worse and worse. The vendor was spilling know-how. There was a very high probability that they were working to the benefit of Mr. Fox's company, biggest competitor, a Polish furniture producer. So how did the vendor lock look like in reality, in practice? Well, all the key functions were delayed. The system was inefficient. The front end, which was responsible for clients placing orders for furniture, it was unavailable. They had a VR mobile app, but it was completely not working. And despite all that, the IT invoices and fees from the vendor were getting higher, higher, and higher. Well, business was not pleased. But fast forward to 1 year after the memorable call we received from Mr. Fox. Well, let's see how things look like now. Vendor is gone. The mobile app, the VR mobile app, gets rave reviews, 5-star rating. Everything is perfect. The IT system works smoothly. There is high efficiency. The IT department is like a well-oiled machine. The business couldn't be happier. And Mr. Fox, for the very first time in a really long time, can get a good night's sleep. You may wonder, how did this happen? Well, we came up with a plan. The plan included a carrot and a stick. And we started with the stick. The stage of the stick included a few actions that had to be taken. And the first one was actually verifying the contracts. The company, the buyer, had a few contracts with the vendor. So we verified all of the contract language. We identified the obligations that the vendor had. And then we started forcing the vendor to deliver on those obligations. We also started verifying the performance of services that the vendor was giving to Mr. Fox for the last 12 months. And it turned out that there is actually a lot of improper performance, a lot of non-performance. So we convinced Mr. Fox to stop the payments. And as a final step of the stick stage, we initiated a targeted litigation with a claim for damages for non-performance of the contract. What was the result of our actions? Good things first. So client acquired all of the source code. They also filled the gaps in their software documentation, and these gaps at some point were huge. And these two elements allowed Mr. Fox to start building the internal IT team that would have the skills and the resources to take over from the vendor and maintain all the systems by themselves. The other result of our actions was also the fact that the client got sued by the vendor for non-payment. Well, it was expected. And this is why nobody panicked. We told Mr. Fox that there is very high possibility that vendor will sue for non-payment. So they kept calm. The organization just simply accepted the fact that they got sued. And the last step that was taken by us and in cooperation with the client, Mr. Fox terminated the contract with the vendor. And that was the moment when it was time to introduce the carrot, a new business opportunity for the vendor. You may wonder, why would we offer them anything? We will move to that in a second. I'll tell you first what was the opportunity that we created together with Mr. Fox. So we offered the vendor that they can take their systems that they have already developed. They are like out-of-the-box systems, ready-made, and implement them and then maintain in a different company within the same group of companies as Mr. Fox's. So we had three elements at play. The targeted litigation we initiated, the non-payment litigation against the client, and the carrot, so the new business opportunity for the vendor. And these three elements allowed us to reach a settlement that led to a peaceful way out of the vendor lock. Well, with the new business opportunity, with the claims, two claims on a different side, the parties were able to come to a conclusion that vendor were smoothly moved from Mr. Fox's company to the other company, and that it will be easy for Mr. Fox to simply take over all of their systems and control them by the company itself. Well, seems rather easy and perfect. It's not always like this, unfortunately. Usually the way out of the vendor lock is either building a whole parallel system that will later replace the system that was controlled by the vendor, or vendor buyout, which means that you are either buying all of the IP rights that are held by the vendor, or you are buying vendor itself. Well, both these scenarios are extremely expensive, and I mean extremely expensive. But there is also a third way, our way. It's cheaper. It's cheap. It's cheap. It's not cheap, but it's cheaper than the two scenarios that we just mentioned. But it's also very difficult. It's difficult because it requires a lot of knowledge about the IT. It also requires courage to take risks. And most importantly, a lot of trust between the client and the lawyers. It's not easy to persuade your client that litigation can actually be a good thing, even when it's a litigation against the client, that litigation can be used as a tool to later on achieve settlement. Because in cases of vendor lock, litigation will never solve the problem. You cannot get out of the vendor lock by simply litigating, but you can use litigation to push the vendor out of your company, out of your organization. So in some cases, litigation is not the solution itself, but it can be used as a tool to achieve greater goals.
It can indeed, it can. And so like vendor lock is a situation where two parties are really close. But in IT, parties can get even closer. And that doesn't always mean it's going to be better. That's what happened to Confidence Corporation. It was a financial sector company which specialized in microloans. And microloans are special in the sense that There is the regulatory framework and clients' expectations. And these two elements change a lot all the time. And that means business processes must change all the time. Business processes are reflected in IT, therefore IT must change. If your IT is complex and kind of old-fashioned, it means that you need to code a lot. That means costs. And Confidence was not in the business of making costs. It was in the business of making profits. Therefore, at a certain point, it started to look for a business processes modeling software, which will be low code, enabling even consultants to prepare new business processes without involving an army of programmers. They couldn't find anyone. There was no tailor-made solution for their needs, but they had know-how. They knew what they wanted. They just needed programmers. So they came up with this creative idea that they will reach out to a vendor, to a company, and we'll discuss this business opportunity with them, that they will give them know-how, ask the vendor to code and create new software, a new platform for business processes modeling based on low coding assumption. And they even thought that, oh, perhaps we can sell it later on and make some additional money on top of that. They found a vendor, they signed an Agile contract, which was the perfect solution for this setup. Why? Because Agile, the Agile contract, agility within helps parties cooperate. Parties get closer in cooperation. In short sprints, they can exchange information. And that contract contained this great vehicle of transferring know-how, user stories. Confidence described their user stories, showed the requirements, and distributed the know-how, delivered the know-how to the vendor this way.
It's also worth mentioning that Agile is just one of the models in which IT projects can be held.
And this one was particularly effective in the context of sharing know-how. Cooperation was like marvelous. The programming was going well. And yes, but you may wait for that question. What could go wrong with Agile Contract and two companies working together? The PSD2 came to the market, and the vendor who was working in financial business was approached by a bank, and that bank signed a contract with the vendor. Contract had huge penalties in it, and the vendor started to be more focused on delivering to the bank. So it moved the team that was working with Confidence to the project with the bank. And what followed were delayed milestones, inferior quality of the software, and that infuriated Confidence. They wanted to have their new BPM delivered on time and with good quality. And due to the fact that the vendor couldn't, the Confidence, it started to look on the vendor not like on a partner anymore, but like on another IT provider. So they called to deliver. They called vendor to deliver on time and with quality, but the vendor couldn't. And Confidence got annoyed and terminated the contract. The vendor also wasn't happy with the termination. They said, like, why? We're supposed to be partners. And Confidence responded, of course, but you were not respecting your commitments. And conversation, you can feel it went in a bad way and ended up in litigation, ended up in the court. It was a difficult claim. Oh, it was difficult. Contract was one world, and parties' performance was totally another world. Parties were creating IP jointly, and the evidence couldn't even allow to divide who is responsible for which IP. And it was so difficult to explain to the judge the sudden change in parties' behavior. We're going to the court hearings with Kinga in Poznań, and I remember at a certain point, judge announcing almost what's the verdict going to be by saying, I can't understand why people believe that the contract must be made in writing. I was coming from the judge. This case was like almost perfect case for settlement. The facts were distant from the contract language. Evidence was witness-based. There was it was impossible to find an expert witness that could actually help with the technical matters, but the client didn't settle. Why? Because this awful element came into play, emotions, and emotions can delay any settlement process. And after sharing those stories with you, it's time to return to the question, the very question of this webinar. Is it reasonable to enter an IT dispute?
Well, keep in mind that over 60% of IT projects fail. And this is for many, many reasons why things in IT can go wrong. Well, and when things go wrong and the project fails, it usually generates a dispute. So in most projects, there will be a dispute. So you should really consider dispute as simply a part of IT project, an almost unavoidable part of IT project. So when you find yourself in a situation of a conflict, you usually wonder what would be the best way to get out of this situation, how to resolve the dispute. So you think, is it more beneficial to settle or to go to court or to go to arbitration? Well, there is no easy answer. It's not a thing. It's not a thing that you can give a rule of thumb on. But based on the 5 stories that we told you today, we decided to prepare a set of questions that you might find helpful in evaluating whether it would be more viable for your business, for your company to settle your dispute or to actually litigate. And these questions are not the ultimate solution. They're not the golden ticket to the world of settlements or litigation in IT world, but they touch upon the issues that are most common in IT projects and IT-related disputes. So the first question you can ask yourself is, was it a one-off project?
The question which follows is a question if there is any hope for further business relationship with the other party.
You should also consider if the litigation can be your tool for achieving other goals.
On a more technical level, you can ask yourself if you really need this system.
Well, also, are you dependent on your vendor?
And is there any alternative which would be cost effective, perhaps something in the cloud?
Well, on topic of costs and money, will this claim actually bring you some money?
And staying with money, can you afford litigation?
And finally, are you ready to wait years for a court decision?
Once you're through those questions, they should help you resolve the dilemma if to litigate or to settle. If you take the litigation path, it's not the end of tough questions. Actually, the more difficult questions arise, and those are technical and legal in nature, and they are in some sense binary, like IT world. If you need them, if you need the response to such question, and the response is 0, probably you should reconsider returning to the settlement stage. And those binary criteria obviously can be multiple, but based on the stories we shared with you and our experience, we want to show you those which we think are the most common and important in the IT world, which is evidence, damages, experts, time, costs. And let's start with evidence. First, the intangibility plays the major role in evidence. You can easily lose access to your evidence, to the coding which took place on the infrastructure of the other party or in the cloud. Without evidence, you don't have a good case. And I also seen clients who came to me and said, please litigate. And when I asked them about the data, they said, all right, but it was on the production environment. It actually got overwritten. It doesn't help your case. Then from our experience, a team which works on IT project, due to the fact that the result is intangible, it's difficult to refer to the result, the recollections of the project, they fade away quickly. And certainly you can counteract these challenges, but you have to remember about counteraction. Then damages. Let's take as an example a support and maintenance contract for software responsible for prepaid services of a telecom company, prepaid cards in a telecom. That software has a bug and the telecom cannot credit the prepaid. What does the telecom lose? It loses profit. Show me a contract in IT which doesn't exclude lost profit from damages. Staying with the maintenance and looking on the other side, if like in Peter's case, you don't get updates, you don't get even patches, but the software does not have bugs. Can you claim damages? Then experts. There is no such thing like IT expert. IT is a vast field, which is separated into little niche specializations. We had problems in finding experts that could be expert witnesses in advanced coding or old kind of coding languages, like I think it was Fortran or COBOL that we couldn't find an expert on, or experts that could advise you on or explain to the court how to calculate remuneration if it is calculated in function points like COSME. And even if you find your expert, because those IT niches are so small, will be often conflicted and won't be able to help you.
IT world is broad, but it's also a very small circle.
Then the shelf life of IT product is short compared to the time of litigation. And if you're not aiming for the money, like with damages or remuneration, but you try to challenge termination of a contract or IP rights, you may end up after 6 years with a court verdict that deals with the product that is outdated. Finally, the issue of cost. Securing evidence so it doesn't perish, preserving that evidence in a way that can be used at the court, and then adding the expert that can explain to the court what actually that data is, what virtualization is, and when you have to partition certain drives. I mean, that costs a lot. And if you compare those costs to the outcome of the case, often costs can outweigh the possible outcome. If your boxes are not checked, then you may have a claim, but you may have not a case.
And if you have already established if you actually have a case, not only a claim, there is one more thing to consider: how your dispute should be resolved. And the choice is actually between litigation and arbitration if you already decided you do not want to settle. But unfortunately, you cannot make this choice after the dispute arose. When you are deciding between litigation and arbitration, you have to do it early on. You have to do it at the stage of contract negotiation, because after the conflict it's almost impossible to sign a contract for arbitration between the parties. And arbitration actually has some advantages over court proceedings, which makes it more viable for some IT projects. And these advantages are, for example, the fact that arbitration is faster. So if you have a product with a short shelf life, or you want to retrieve money quickly to reinvest it into a new system, then arbitration will probably be a better choice. The other thing is the issue of confidentiality. IT projects very often deal with sensitive data, with a lot of know-how, innovative ideas. And well, the buyers or the vendors, they do not want this sensitive data to be leaked to the general public. And the fact that arbitration offers a lot of confidential securities, it means that it will be more beneficial for many IT projects. Also, arbitration is actually less expensive than you may think. With lengthy litigation that generates a lot of costs, it can actually turn out that litigation will be much more expensive than arbitration. And you can also pick a procedure like fast-track arbitration, which is offered by many arbitral institutions and is much more cost-effective. The other thing, Wojciech talked a lot about experts and how it's difficult to find an expert. With arbitration, there is more flexibility in introducing foreign experts from different jurisdictions into their proceedings. So you have more candidates that can possibly explain what is the main issue of the dispute. Also, from our experience, experts are more willing to testify in arbitration than in litigation, among others, because of the thing of confidentiality. The last thing is the freedom of language. Well, it may seem rather obvious that in arbitration you can choose the language of the proceedings, But this is not so obvious in national courts. When thinking about going to litigation and going to a national court, you may be surprised that in some countries, courts will not admit evidence in any language other than local language. And now we're in IT world, there is huge amount of software documentation. This documentation is usually in English, and now you have to translate all of it. It generates a lot of additional costs. With arbitration, there is no problem. You are simply choosing English and all the evidence is submitted in English. But even though arbitration has so much to offer, especially for IT projects and IT world, it is underestimated in IT. Well, it's because when parties are negotiating the contract, the IT contract, nobody is expecting that their project will evolve into some kind of conflict, into a dispute. Well, our cooperation is great. We are both great. Nothing is going to go wrong. Why should we think about it? Well, this is really an unrealistic expectation. Keep in mind, more than 1 in 2 IT projects end in failure and dispute. So even though parties would be much better off with arbitrating their case, they are forced to go to a national court because there was no arbitration clause in their IT contract. What we can recommend? Well, we recommend believing in the statistics. It is really common for the IT projects to fail. And truly consider adding an arbitration clause to your IT contract, because you will be probably better off with it than without it.
Right. Will be.
I'm sure.
At this stage of the webinar, we owe you an answer to the question, is it worth to litigate an IT project? But we won't give it to you. It's impossible. Every project is different. It has its own dynamic, its own set of problems. We can give you experience, we can give you criteria, we can give you questions that will help you evaluate what's the best solution for you. But for sure, we cannot give you one answer.
And on that terrible disappointment, it is time to end our part of the presentation. Let's move on to the comments from our co-speakers.
And if I may just jump in here, I think it might be worth getting the audience's votes or views on whether it's worth litigating an IT project. So perhaps if I can launch a poll while our 2 guest speakers introduce themselves, we can canvass some opinions of the audience in the room, if that's okay with you guys.
Sounds perfect.
Excellent. So to those watching, we have a poll on the screen, which you are invited and indeed encouraged to vote on. We'd be delighted to see your views on that. So while you're voting, I will ask Magdalena to introduce herself. Magdalena, please.
Hi, hello, good morning and good evening or afternoon to some people who may be within different time zones. It's a pleasure to be here with you. My name is Magdalena Krusitva. I'm an attorney, and also I am the head of the legal department of the telecommunications sector at Comarch, which is a global provider of IT services and IT products.
Excellent, thank you very much. And Stanislav, could you introduce yourself, please?
Yes, thank you, James. Thank you, everybody, for coming to watch the webinar. My name is Stanislav Hajewski. I'm the General Counsel and Director of the Legal Department at Centralna Ośrodek Informatyki, which roughly translates to Center of IT, a public sector IT provider. And here we mainly handle issues relating to IT procurement and IT contracts, and of course other sector-specific issues such as data protection, cybersecurity, and electronic identification.
Excellent, thank you. And just to briefly respond to a question we've had in chat as to why there is no "it depends" option on the poll, because we wanted to force a hard choice and get a view of whether or not you think it is worth litigating in a situation where litigation is at least a viable option. Obviously, it depends in all cases, but we wanted to force a hard choice on you. And with that, you can see 55% say no, it is not worth litigating. So it appears that marginally, the no's have it. I don't know if that surprises you, Wojciech and Kinga, but it certainly appears that it's the no's that carry it.
It actually doesn't surprise us.
No, I thought that would be the answer. I'm surprised it's not a stronger vote in favour of no. But anyway, that's what the audience says. So with that, I will turn back over to you to interrogate our two expert external speakers.
If I may, looking at the first case mentioned by Kinga and Wojciech, my view as an in-house for an IT provider is obviously quite different from the client's perspective. But I think that it's really crucial to actually implement on both ends. I'm thinking about the IT supplier, but the client should do it as well, to implement and actually use proper tools to register all the activities within the project, and actually to have it registered in both ways. So the client has it on their premises, and the supplier also has to properly conduct its own register of all the activities. And the other thing that I think wasn't mentioned here is that the IT world is very, it's changing rapidly. This is one thing, this was mentioned, but the people in the IT market, they change their jobs very often. And we may face a situation that we will not have people who actually delivered the project, were engaged in the project, and there is no one to talk about the situation within the organization, both on the client side and also on our side. So from the supplier perspective, it's very important to actually keep the people within the organization, and to know how crucial it is to have people that know the reality of the project that actually went wrong at some point. So this is my first thing that I wanted to mention. And about the second case, about this very ambitious vendor, I think a very good way to avoid the kind of situations is that to properly get to know each other before the signature of the contract. I'm working in an industry where the contracts are usually very complex and very costly as well, because those are very, as I said, very complex contract very complex IT systems implemented for usually telecommunication sector companies. So we basically face very numerous workshops before the contract is signed. We are facing a lot of proof of concepts as well. So before the contract is actually signed, both parties know each other very well, and they know the product very well as well. So this is one of the ways to actually avoid future problems and disappointments as well on the way.
Sure, Kinga, if you don't mind, I will follow on the first point and perhaps let you follow on your story. That was perfect observation regarding the first point. That was the story of a vendor who lost a sponsor of the project within the organization. And you mentioned, Magdalena, that's maybe a challenge with witnesses, keeping them in the company. So I can imagine that in Comar you have good motivation systems for the people to stay, to motivate them in staying in a company. But we faced even another challenge when litigating. We litigate on both vendor and buyer side, depending on the sector, to avoid conflict of interests. And in one of the sectors, I remember discussion with the vendor and with the witnesses who were completely unwilling to testify in the court against the buyer. Why? Because they were thinking a couple of steps ahead, and they thought, right, but if I change the job, I'll be working for someone else, and now I will testify against the buyer, it may affect my work opportunities in the future. And they were unwilling to testify. What also supports this evidence issue, and that the settlement may be a better solution.
Yeah, in terms of the second part of what Magdalena said, that's true. Getting to know your vendor, your buyer, analyzing the project together, it's really important. But sometimes I think parties just simply may not have time to do that. In terms of projects that have to happen fast, there is a lot of pressure on the buyer to implement the project as soon as possible. Then sometimes the part where parties get to know each other is simply skipped. It's certainly very important. I agree on that. Both parties are better off knowing each other, knowing each other's resources, their capabilities. But the story that I told about the vendor who was overly ambitious, this was actually the case where, due to the pandemic, due to how fast the system had to be implemented, there was no chance for them to get to know each other.
And by the way, have you faced those troubles at Comarch that your witnesses did not want to testify in the court?
Fortunately not. At some point, I've seen a problem, but not on our end, but on the client's end, that, as I mentioned, actually almost all the team that was cooperating with us for the implementation of the project, of the product, disappeared. Those people just moved to a different organization. And there was actually no one on the client's end who knew what happened and actually why the project did not go well. Also, some documentation was lost. So actually, from our perspective, it was an ideal situation. We just felt that it's a very good opportunity to actually settle with the client, because they had a really huge problem with evidence, and also in respect to witness and also the documentation. They did not properly handle the project, and we did, fortunately. So and we did settle in this case, and I think it was a very good option for both parties.
I think that's an important point, if I could jump in. For there to be any choice, because we're talking about a choice, is it worth it to litigate IT projects? I mean, the fundamental thing is to have all your options open. And that comes down to, especially for in-house counsel, for preparing the contract itself and preparing your organization for the contract. And what I mean by that is making sure, for instance, that your project management team knows what the contract entails, that they know how to operate within the contract parameters, that your IT professionals know what your exit strategy could be, what you can do, and what options you have on the table. So when a conflict arises, you're prepared for that conflict. You're retaining your knowledge in some way. You're documenting when you have issues, you document what the solutions are, what's the source of the issue. So even if a team leaves or something changes dramatically, you can go back to that information and use it. And then making a choice and telling your board that we're either going to litigate in this situation or we're going to settle is that much easier. Because I mean, every time a claim arises in my line of work, it's always been the first question is to really audit yourself, to think about what your situation is, how strong your case is. Do you have any kind of arguments that you can actually use in this situation? Because you usually don't, and that's another thing, if you're not organized, if you're not ready for this kind of thing from the beginning, which we touched on a bit in the presentation earlier, you usually don't have the time to really go into every detail, to sort of backtrack and find everything out. You have to have all that information ready. So it's a very important point to really prepare your organization to the possibility that at some point an IT project will not work out. And looking at the statistics, there's a big chance it won't work out. One of your IT projects is definitely going to have a problem. So you always have to sort of look ahead in that way.
I couldn't agree more with that. And the more you invest during the contract negotiation and the contract execution stage, when the performances are made, and you don't have to really invest in lawyers at that stage. I mean, you may, of course, invite you, but even if you invest like in proper PM, like tracking communications and like having order on your project, that will benefit you in the future if the claim, if there is a case, if there is litigation, or actually that may help in avoiding litigation. I remember back in 2010, in one of the companies, I had a PM saying that he loves, after signing a contract, making that contract confidential and not showing it to the team. And I can tell you that that company, up to this moment, tries to implement the system that PM was referring to 11 years ago. And this is certainly not a good attitude, not a good approach on managing contracts. As you said, Stanisław, good preparation and knowing your documents is key to success and avoiding the unnecessary costs.
If I may, refer to the cost aspect of deciding whether to litigate or settle. Whenever we internally in Comach try to take the decision on this, we take into account all the aspects, all the cost aspects. One thing is obviously external law firm fees, because we usually engage external law firms if we have a dispute, especially abroad, but not always. Also local litigation we handle in many situations, but via external law firms. This is one thing. Cost of arbitration or litigation before the court, this is also important. And Kinga mentioned that arbitration may not be that costly. I can agree to this, looking at the periods of the litigation, because I've seen a case in which the proceeding, it wasn't in Poland, in a different country within European Union. The litigation in the first instance lasted for 5 years, and there was no first instance judgment yet. So the parties decided to settle because it took too long for them. So yeah, we had the settlement then. But ICC, for example, can be quite costly, and other tribunals. So we can look at the cost at the websites, right? We can, if we have 3 arbitrators, the cost can be extremely high if we are talking about high costly disputes. So the disputes is around big money. So another aspect is internal in-house lawyers' mandate costs, because we need to engage a lot of people internally to properly prepare for the litigation or arbitration. Internal IT specialists mandate costs as well. These people would be working on different projects, different ongoing projects or prospect projects, and actually earn the money for the company and not burn mandates. Yeah, as Kinga mentioned, if we don't choose arbitration, there could be significant cost of translating all the documents, and we are talking about not even hundreds, thousands of pages of different documents, and also expert opinions. So if we summarize all of those costs and sum it up, we may end up with a very, very high cost of actually going for a dispute.
That's true, and in the sense that arbitration can obviously result in ultimately lower fees, and especially if you look from the time perspective. I mean, you have resolution, you have money quicker, or you know where you are at. And but it's interesting point about 5 years in the first instance. We have one of the cases. I think it's already 8 years, and it's difficult to do anything about it. But perhaps such a long time in the first instance could be the strategy of the judge to convince that the settlement is the only solution.
Yes, I've seen that kind of cases as well, right?
And on the issue of cost, if I may add one thing, is that there are a lot of hidden costs, as Magdalena said, but other advantage of arbitration is that you can retrieve more costs in arbitration that you would in litigation, because you may file for cost reimbursement for many more things than you would in a national court.
But I would like to follow on your comment that you calculate in Komar costs of litigation, and actually ask this question to you, Magdalena, and to you, Stanisław, because there's this message that we are trying to push on you is that if you have to go to litigation, you can consider your claim as a project. So you should calculate exactly your costs, risks of success, and possible outcome, and basically evaluate if investing time and money into the project of litigation is worth it. Do you have this kind of discussions internally in your companies?
I think every decision any decision to go into litigation has to have some kind of risk-based analysis, right? Risk, costs, everything involved. Because, I mean, a lot of times we get very emotional about these things, right? Because we invested a lot of years, a lot of work into a project that's not working, and we want somebody to show us that we're right. But at the end of the day, this is a business decision always, right? There are some external factors you have to take into account. There's a certain amount of costs, man hours, what Magda said earlier, the amount of work internally that has to be done for litigation to be successful is very large. So it's always a discussion you have to have with various departments in your company, with external lawyers about all aspects of a case, and then only then can you really make a decision. I mean, every decision for me has been like that. There's very rarely litigation that's very simple, right? I mean, especially in IT. Maybe if you have a service contract with a clear service level agreement where you have contractual penalties, sometimes you can just say, yeah, you were late 3 hours, so here's the penalty, and that's that. But I've rarely found those kind of situations in my experience.
I've seen situations in which, for example, on the client's end, the project manager did not properly show to the management how the project is being implemented or why it did not succeed. And at some point, actually, litigation helped to show the client management that the IT provider wasn't the one to be blamed for it. And it was even substantiated by the specialists, by the experts, external experts. And I've seen situations in which the client would then agree to settle or even encourage settlement and decided to engage the company for another project. So, I mean, those are really interesting scenarios that we are facing in IT world. And I mean, it's a good approach to treat it as some kind of a project, the litigation. And I did encounter that kind of situations, and I think it's an interesting way of handling this thing.
I'll actually, just one more thing to add. I actually hired somebody with project management experience to my legal team exactly for reasons like this, because these kind of, not specifically for litigation, but I mean, a lot of legal projects, because I'm seeing the benefits of that kind of approach to legal problems in general. So litigation is no exception to that. And I would highly recommend it on my own experience.
I couldn't agree more. Litigation is just a project.
Yes, and if I may, about the aspect of burning the bridges, which was also mentioned in one of the cases, it's very interesting from my perspective, and I also think that it's a very important aspect to be taken into account, and it also depends on what kind of market you actually operate. For example, I've been advising for the telecommunication projects mostly in recent years. And on this market, you don't really have that many players. So if you burn bridges with one telco global operator, you may be actually burning bridges with many other entities as well, because they have affiliates all over the world. In this world, we also face mergers and acquisitions, and some entity may not be your client at this point, but it could be acquired by another entity, and now you have a problem with two big players on the market or one huge player on the market. So I do believe that it's very important to take into account and to actually look at the situation of the client, what's going on within the client. Is it going to be, as I said, maybe acquired by someone else? Will you be burning bridges with this specific entity, or maybe with dozens of entities all over the world? So you need to think very carefully before getting into disputes.
The issue of relationship is very important, as you said, Magda. Would you agree that actually the thing that parties want to maintain a relationship, not burn bridges, is the factor that can outweigh anything else?
In some situations, I do believe that this is the most important factor. And I've seen situations in which the clients, the supplier did provide services for one client, one of its divisions provided services for one client. This project did not really go well, but there was a great project implemented by another division of the organization, and the client was extremely happy about it. It was a similar case to yours. And just it simply wasn't a good idea to stop the relationship, to burn the bridges here, but to try to resolve the matter in a constructive way and to continue the relationship between the parties.
And Stanisław, how does it look like from client's perspective?
Well, I mean, I think business relationships are one of the most essential things that you are trying to cultivate during an IT contract, because I mean, it's a very long process. It requires a lot of working together. So honestly, I think it's crucial. It is crucial to maintain those relationships and be very close. And I think that's what really helps with conflict, of course. Honestly, I think that kind of constant communication is what really stops a lot of conflicts before they happen. Sorry.
Yeah, can I drop in and say something about the arbitration as well? Whenever I'm preparing the contract and we are negotiating, Coma is negotiating a contract with the client, we are obviously deciding whether to have an arbitration clause, to decide for arbitration at this point, or to decide on the courts. And one important aspect to be taken account as well, apart from the ones that you've mentioned, Wojciech and Kinga, is also the matter of enforcement of judgment. Because and when we look at the New York Convention, 166 countries are signatories of are contracting parties to this convention. So in so many situations, it's actually the only option, the only reasonable option. So many Asian countries are contracting parties to this convention and don't have any bilateral contracts with countries, for example, from European Union. So if you choose not to arbitrate but to litigate, you would be facing a situation in which it would be maybe even impossible to enforce the judgment. So I think this is also very, very important to take into account. And I'm always looking at this aspect at this point of negotiations.
I think it's
that's what we were talking about. Sorry. That's what we were talking about earlier with contract preparation, right? I mean, that's one of the things you have to prepare for at the beginning, right? Rather than the end. So that's something that any legal team has to assess every time they enter into a contractual obligation, which, well, anywhere basically, but especially in a sort of international context.
Yeah, I think it's also important factor that national courts more and more likely enforce and recognize arbitral awards. there is more and more, decisions rendered that are in favor of arbitration and that are actually trying not to kill the decision rendered by the arbitral tribunal, but to rather uphold it. And this is also important for international setting with two parties from different countries doing the same IT project. I agree with Magdalena that arbitration here is often the better choice also for the enforcement reasons.
Yes, and I think that another aspect I've been facing is that, for example, when you sign the contract with the clients, if the relationship is good, the contract may last for decades even. I mean, I've seen contracts which lasted for 20 years, for example. So when the contract was actually drafted, it could be a good option to choose the court. But the political situation in the country could have changed. And I'm thinking about different, sometimes very exotic destinations. At least Comarch is a very global corporation at this point. So we are contracting with companies from all over the world, literally. And after decades, the judicial system in some country could be very problematic, could be corrupted as well. So, I mean, those are really those are situations that we really face. So if we had chosen international arbitration at this point, we wouldn't be facing such problems later on. So this is a very practical aspect, and we need to think of this. I mean, it's hard to predict that kind of situation sometimes, but it can happen as well.
True. So it seems like everybody likes arbitration. So let me just...
I certainly do.
Let me just add another comment. Sure, but that's the optimal path, right? That arbitration is quick, fast, effective when it comes to costs, and you can execute your award. Unless the country is that corrupted that you cannot, or you get challenged to your arbitration award and end up tied in a court dispute, then in the public court of that jurisdiction for more years than litigation could take place. I mean, arbitration, it's not, again, a silver bullet to everything. When people, especially emotionally, get involved into disputes, I mean, it's so difficult often to achieve any resolution in any reasonable time.
I mean, Roger, I do agree with you. Because it really depends, at least in my case, from where the contracting parties are seated. If I'm facing two entities operating within the European Union, I would most probably use court. Definitely, I wouldn't choose arbitration. Even if I face a contract between a Polish entity and an entity from the United States, I would as well, I believe, choose court. But if a problem appears, I would definitely encourage both parties to settle, especially because of the reasonable attorney's fees in some in some US states. So I think that litigation in court may be a much better solution in many countries. Mm-hmm. But as I said, when I look at, for example, Asia or other countries which are signatories of the New York Convention and don't have bilateral contracts with some states, then I'm thinking about arbitration usually.
Sure. Magdalena, Stanisław, there are no more questions for me. Perhaps we could try to reach James and maybe he can help us with the questions that appear in the comments. James.
Yes, my turn. So I'm going to, we've had quite a few. So I'm going to read these in reverse order, if I may. So the first one that might be of interest here is someone's asking how important exemption clauses are in IT contracts. about when it comes to litigation. And I think they're specifically asking whether exemption clauses in the contract tend to hold up in court or whether they get challenged. I don't know if anyone has any thoughts on that.
What kinds of exemptions I would dare to ask in more detail?
Well, perhaps if the questioner can get back to us with a bit more detail on that. The question's just asking about exemption clauses as a general class, but I don't know if Wojciech or Kinga, if you've ever come across the exemption clauses in an IT contract that have been overturned or challenged by the court during a litigation. Is that something you've ever encountered?
No, not really. Didn't have experience with such thing.
Okay, great. So we'll move on to the next one. So a call to the questioner. If you can give us a bit more detail there, we'll take it in just a second. So the next question, aside from litigating tech contracts or IT contracts, the question is asking about your thoughts as a panel on termination. And the question says, often it can be just as difficult to terminate a contract. So what are your thoughts there? I mean, do you have any advice or tips when it comes to terminating an IT contract if parties underperforming and you want to get rid of them, move somebody else in? What are your thoughts there?
If I may start, I mean,
yes.
I love terminations which were done by the other party without my advice. They always leave so much room for litigation. Because terminating IT relationship is difficult. Usually there are like plenty of layers of that relationship from the legal perspective, and you have to be so invested into local law to know how to terminate the contract effectively. What kind of contract is involved, which type, how should you terminate it? Should you terminate only services or perhaps also the implementation part, and then the licensing? How do you terminate licensing? Can you actually terminate it? How precise you must be? I mean, I love terminations from a purely professional perspective and what opportunities they offer in terms of arguments.
Anyone else have any experience? Stanislav, look like you.
Yeah, I mean, when it comes to termination, I think the most important aspect is, are you prepared for termination? And that's the question you have to ask yourself. Because I mean, that's the most important thing. Because of course, claims come afterwards, and a lot of different things happen. But I'm saying in like a business and technical sense. I mean, I think that for me, that's always, from a business perspective, even more important. Because the legal aspects, I mean, in a few years, they'll get resolved in some way or another. But for your organization, any kind of termination of an IT, well, usually a termination of an IT contract is some kind of sort of shock. You have to plan ahead. You have to implement something new. You have to replace one thing with another thing. It's very complicated just organizationally to get ready for a process like that. And I think that's something that often gets sort of lost in that decision, which is often just our vendor is not providing the services we need. We're very emotional about that fact, and we just want to terminate the contract. We want to have some kind of, so in some way, we want to punish them for their bad performance, right? And we really have to look at it again as a sort of value-based decision. Is this going to help our organization? Is this going to get us somewhere? Or is it just going to generate more problems than we already have? So that's it's very important to plan ahead. And again, we go back to planning your contract. When you're writing your contract, and if it's a very complicated IT system that you're implementing, or these are crucial services, you have to think about how you can get out of that contract. So exit plans are a must in any kind of contractual relationship of that type.
I do agree with Stanislav. We sometimes even take, weeks to properly negotiate exit provisions in contracts, disengagement provisions. And it's also so important to then update the disengagement plans annually or even more often. So as Stanislav said, it's crucial to actually prepare for the termination of the contract. And because if you don't, then it will basically create much more problems than sticking with the existing supplier and encouraging it like with proper tools to just basically deliver better services, better product.
Excellent. Okay. Sorry, cough. Okay, so I guess the next question seems to, it touches upon a number of things that you touched upon in the presentation and in the discussion, but I guess it's an important question because it summarizes so much of what has been discussed. So the questioner asks or states, it's fairly common in IT projects to avoid, wherever possible, a rigid contract that doesn't allow for collaboration and flexibility. Obviously, deliverables, objectives are constantly changing, and the preferred form of relationship between parties is a flexible one that isn't tied together in a rigid contract, because that just doesn't work for the types of projects that they're contracting for. So the question says, project deliverables change all the time. No one wants to second guess what the end goal will be. However, when it leads to trouble, when a project runs into trouble, that can be a difficulty. So what's your best advice or best practice for capturing the essence of an IT project without tying the parties together in a rigid contract? So I guess it's a question of strategy and tactics. How ought people to approach an IT project with half an eye on the possibility of things going wrong?
Oh, that's like a subject for another webinar, how to properly write IT contracts without killing the performance on the side of both parties. I mean, it's just a business case. I remember well working on an IT system for which prerequisites were written under one European Union fund, which was the money for those prerequisites. They came like 3 or 4 years before the deployment began. So it was already outdated upon the commencement of deployment, and the contract had no flexible provisions, no change management procedure. It was really difficult to execute that contract, and I couldn't agree more on that specific example that flexibility is necessary. From time to time, like strict contracts also, they're often, they may be used by the clients to enforce performance on the side of the vendor. If the vendor loses interest in performing the contract because, for instance, he has another more interesting project. So I think I cannot agree that in 100% of cases, having a lot of flexibility helps. Sometimes you need tools to be able to execute the contract, and often the environment around the contract does not allow for flexibility. Even the parties are willing to have some flexibility. I'm pretty sure that Stanisław can have some thoughts on that, being at least to a certain extent within the public sector that has its change management process a little bit limited compared to the private sector. Isn't that the case, Stanisław?
Well, definitely. I mean, definitely, you can't be as how would you put it, agile, right? In many contracts in this sector, but I mean, I think that's also it's not also true that you can't at all be flexible in such contracts. I think it's important really to look at project management as the most important part of any contract where you want to be more flexible. And I think that this is where, so to speak, all the bodies are buried. If you have a very well-defined change management system, if your project managers know what they're doing within the contract and how to ascertain what exactly you're trying to build at any given moment during the contract's performance, you're going to be okay if there's a conflict, because there's a very strict procedure that they're following that gives you flexibility in terms of performance of the contract, but not in terms of changing everything in the contract without any rules, right? So that's what you should really focus on, how your project management teams are going to define what is the scope of the project at any given time during the project, so you can go back and you can see what changes were agreed to, which are not agreed to, and those kind of things are essential. And I think also a lot of times when we talk about flexible contracts, we seem to think that that means the parties don't know what they want. And I think that's also a bit of a misinterpretation, because Agile is a way of performing a contract. It is not a way of defining its goals, because you should know what you want to build in the end. It's how you get there that Agile allows you to be more flexible about. So that's also very important. So as I said, I mean, project management, I think, is key in these situations. And in the contract has to have the appropriate clauses, the appropriate project management clauses implemented. Your lawyers need to know them, and your project management team needs to know them, because often these roles are divided. So the project management team writes the rules for project management, and the lawyers only write the contract. And that is also a very bad situation. So you have to sort of mesh these two worlds together and get them talking to really have success with a flexible contract.
Excellent. Okay. Another question, very specific and short one. So I think Magda, you mentioned in the panel, and everyone seemed to agree that it's rare to pursue a dispute because obviously it's a small world, and you don't want to get a bad reputation or to fall out with potential counterparties. But someone's asked, are there cases where a company in this sector will litigate purely to make a statement to competitors? So kind of the opposite of what you're saying, where you'll pursue a dispute just to send a signal that you're likely to defend your interests and not be messed with. Is that, I don't know if anyone has any thoughts on that. Wojciech's smiling, so I don't know if you...
Was this question directed to Magda, wasn't it?
Well, anyone can jump in, but Magda, if you have any thoughts on that, please.
I mean, I've seen that kind of disputes, especially in the public sector, where actually the IT provider, would file a claim to show the competitors that, I'm a player with whom you cannot you have to treat very, very seriously. And I've seen a case in which it ended up quite well, and it was a good tactic to actually do this. But for me, I've seen the kind of cases I said mostly in the public sector. In the private sector, I believe there is much more space for settlement and actually not following that kind of tactics.
Mm-hmm.
And like Kinga said in one of her in part of her presentation, litigation can be used as a tool, and we are involved in a couple of litigations where that litigation is a tool not directed on that particular opponent on the other side, but on the broader market. And the client has to push the claim, even though costs of conducting the claim in front of the court, they outweigh the outcome many times. But if you multiply it by for instance, number of implementations they did or number of software they delivered to another clients, they just must push the claim to prove they are not wrong in what they are saying, because that can really affect them. And that's how we use litigation as a tool.
I also think that emotions play a role. Sometimes litigation will be used just as, banging on a table saying, no more, we are not going to cooperate with you any longer, even if that would bring better reputation to a certain company. That just emotions are so high and so boiled up. It's just sometimes a way to just cut the sentence in the middle and say no more.
Excellent. Yeah, look, we have several more questions, but I know a couple of you have a hard stop and need to leave. So in the interest of time, we'll have to leave it there. So to anyone else who has asked a question, we will get back to you after the webinar if you've left your email on Zoom. But there is one final question I'd like to address, and I can answer this one. It is, it was a statement at first, a wonderful presentation. The question is, are the slides going to be available elsewhere? I think the answer to that is yes, but perhaps I can check with Wojciech and Kinga. Are we permitted to repost the slides on our website?
Yes, of course.
Excellent, great. So we will have those up along with a recording of this discussion, so you can watch it again at your leisure. A huge thank you to Wojciech and Kinga of Maruta for a wonderful presentation, really interesting discussion. And of course to Magdalena and Stanislav for joining us. Really fascinating to get your insights, really grateful that you could join us. And of course, thanks to you in the audience for watching. If you have any further questions, please do email me. You can get my email on the webinar webpage, and I'll pass them on to the relevant person. But thanks again. And any final words from either Wojciech and Kinga or from our panel?
Well, thanks to everyone who attended the webinar. We hope you learned at least a bit about IT litigation.
And we hope you settle well.
Excellent.
Yes. Thank you very much. It was a pleasure to be here with you.
Thanks, guys.
Thank you.